you can enter your questions in the chat box on the bottom left-hand corner of your screen. We're going to cover as many as we can in the allotted time, but we will end at 2:45. So if we didn't get your question answered, please feel free to call Raman or myself, and we'll have that information as our last slide. So you'll have that available to you. So welcome, Raman.
Thanks, Joan. It's a pleasure to be here.
Good. Well, I know so many of my clients, and I'm sure yours, are going to really appreciate an expert in transactions to, you don't very often get free advice from attorneys, so we're glad to have you here today. So the first question I have is, why is it important for business owners who are already strapped for time to focus attention on potential sale? Why is that important?
John, I'm going to get to that in a second, but I just wanted to say real quickly that it's a pleasure being here today, and I always enjoy working with you and your team. And not only do you bring a wealth of experience to the transactions, but I find that your clients tend to be really well prepared for these transactions. And I mean, they're prepared in terms of having their I's dotted and their T's crossed and their documents ready and that sort of thing, but also that they're mentally prepared for what's usually a very emotional and trying process.
Yeah, that's half the battle, isn't it?
Yeah. I mean, for us, these transactions we do several of these per year, but for most business owners, this may be their one time or their second time going through a transaction like this, so it weighs very heavily on the minds of our clients.
Yeah, that's true. So thank you. So if you could answer that first question,
sure.
Why is it important for business owners who are already strapped for time to focus attention on a potential sale?
Yeah, I think that's one of the main, sort of the one common thread between all business owners, and at least with small and mid-sized companies, is that they're strapped for time. They barely have enough time to keep their business sort of just operating normally on a day-to-day basis. And so the question is, why should they be focusing on the long term? Why should they be focusing on their exit strategy? And I always think of the Dallas Cowboys as being a great example of why it's so important. In 1984, a gentleman by the name of H.R. Byrne Bright, he purchased the Dallas Cowboys NFL football team, and he paid $85 million for the team in 1984. It was a pretty good team. It was one of the marquee franchises in the National Football League. It actually had a win-loss record of 9 wins against 7 losses in 1984. He owned the team for 4 years, purchased it for $85 million, and during his 4-year tenure, he pretty much ran the team into the ground. And by the time he sold the team in 1988, the win-loss record of the team was 3-13. So he had taken one of these great franchises and really not done well. When he sold the team, though, he sold it for $170 million. So even though his management style wasn't very good, apparently, and the results of his efforts were not good, he doubled his money. So sometimes we can lose track of the fact that there's often opportunities when you're selling your business to actually make more money than you would sort of running the business on a day-to-day basis, and that's why it's always important to keep your eye on the ultimate goal, your more 3 to 5 year outlook, as opposed to, or I guess as well as your day-to-day outlook.
You're absolutely right, and I found that even people that have called and said they're ready to sell, and the more you start talking to them, they just freak at the idea that they're going to have meetings, they're going to have time to take their eye off the ball, so to speak, to be able to meet with potential investors and buyers, and then going through the whole asset purchase agreement or the stock sale can really hurt, and it can hurt the business.
That's right.
Yeah. So they have to be, I think, like you said, the more prepared they are and having all their ducks in a row, that they're going to, the time that they spend with clients won't hurt so badly. So.
Right, and they have to just recognize that there's a lot of value, even though it takes your eye off the ball in terms of the day-to-day operations. There's potentially a lot of value if you can negotiate good terms.
That's true. That's true. Okay. The next question is, for the purchase price, what is the key component a seller should look for?
Well, I mean, the easy answer, of course, is cash. I mean, everybody would want to be able to sell their business sort of like in the same manner that you sell your house, where, you know, there's a bank that comes in and hands you a check for 100% of the purchase price for your house, and you walk out the door. But, you know, in my experience, that's the only time I've ever seen deals that close for 100% cash is when the cash price is so low that it's basically the business is being sold as a kind of a fire sale, and the seller's not getting any real value out of the business. In my experience, all transactions of any substantive value are going to be the purchase price is going to be made partially of cash, but also through some sort of future consideration. And the most common types of future consideration would be either some sort of an earn-out, where the seller is going to receive some sort of a royalty based on the performance of the business after the closing, or some sort of a loan, a promissory note that may be held by the seller.
And it's often, I found that it's often both. You know, their seller has to carry more now than they ever have had to, because banks are just being so cautious about lending.
Well, I mean, I think that brings up the point that the economic climate is always very relevant. You know, when I started practicing years and years ago during the dot-com era, when there was multiple IPOs every year, what was common was people were pitching these roll-up transactions where they would come to a seller and they say, hey, I'm going to buy your business, and I'm going to buy 10 other businesses just like your business. We're going to roll all these businesses together and we're going to go public. And they were selling this idea that you don't need to get cash because you're going to get stock in the IPO. And a lot of people, you know, there probably were successful transactions, but there were a lot of unsuccessful transactions. So you do want to make sure that, you know, you are going to be comfortable with the cash consideration of that you get, but also have to be realistic and expect that there's going to be an earn-out or a note. And you're right. I mean, in today's climate, there aren't any IPOs, but what we're dealing with now are banks that are reluctant to lend, especially to small business. And so the sellers are having to be a little bit more flexible and carry in terms of showing a willingness to carry back a lot of the purchase price.
Right. And what I always try to, you know, use as an example for a seller that says, I want all cash, you know, and let's say it's an $800,000 transaction, you know, if somebody had $800,000 cash, they're going to put $800,000 down on a $3 million business and leverage instead of putting it all into one business.
That's exactly right.
You know, so it's just not going to happen. And have you found that it's typically a 3 or 5 year time period that a seller has to carry a note?
Yes, I mean, I think 3 years is very common, 3 to 5 years. And for a note, you probably would be pushing more towards the 5. And then for an earn-out type of consideration, you'd probably be pushing more towards the 3. The other thing that an earn-out can do or a note can do is fill a void or a gap between what a seller thinks a business is worth and what a buyer is willing to pay. And oftentimes a seller wants a certain price. They have a certain price in their mind.
Right.
And a buyer is only able to come up with, you know, a portion of that. And so an earn-out is a real nice way for the seller to say, look, I know the business is going to be successful and generate a certain amount of profit. So let's take a portion of the purchase price and we'll split that profit, so to speak. And so it's a good way to bring parties together.
Yes.
When they're a little bit far apart on the purchase price.
That's true. And I, even for a note, have recommended at times when the cash flow was just going to be hurt too badly in a 3-year note, that even do it a 10-year note, but have it due in 5. You know, so then the payments are less for the buyer, but there's going to be a balloon payment in 5 years for the difference of what the principal that's left, and that's worked out well. And
yeah.
SBA, if there's partial SBA funding and partial buyer and then partial seller, they really want it over a 10-year period if the SBA is involved. which most sellers don't want it over 10, so they usually will have an agreement with the seller that there's going to be a balloon in 5.
Mm-hmm.
So, well, good. I'm glad you touched on that because so many sellers think they're going to get all cash. And another advantage, Raman, would you agree that they don't have to pay tax on it until they get it?
Right, and I'll just say that if I'm representing the buyer in a transaction, I would never allow a client to pay all cash.
Right.
I mean, that would be just so that would be my number one piece of advice to the buyer is you've got to hold back a portion of the price just in case there's a skeleton in the closet that you're not being told about.
Absolutely.
If for no other reason.
Very good point. So if let's say if there isn't an earnout but there's a loan, and you find something down the road that's going to definitely affect how much that business is making that's contrary to what the seller said, then that note can be offset, correct?
Exactly.
Okay, good. We're kind of on earnout, so let's go to what are the most common disputes to arise out of earnouts?
Yeah, transactions generally work well, but being an attorney, I often get to see the transactions that don't work out so well. Right. And I would say the most common dispute that arises after the closing of a transaction is some dispute related to the earnout. Mm-hmm. And there's basically 2 categories of disputes. One is just an interpretation issue, and you have to go to the earnout terms and try to figure out what they mean. And the problem is that most business owners, most attorneys are not well versed in accounting terms, and usually the earnout is heavily reliant on accounting terms, and accounting terms can be sort of notorious for being subject to interpretation. Okay. So one thing to try. Do you
recommend when somebody is doing an earnout? Do you recommend that the same the same financial structure or a system that they used in the past to come up with EBITDA or seller's discretionary earnings, that they use the same format for the next 3 years during that earnout so that there isn't any discrepancy on that, or can that be changed?
Exactly. That's one of my favorite ways to deal with this problem is to say that the earnings in the future are going to be evaluated using the same methodology that the seller uses before the closing, so that we're comparing before and after the closing, we're comparing apples to apples. Good. You don't always get that. The buyer will want to use their own accounting system, but you just have to it's not so important. It may not be so important how you resolve the problem, but just recognizing it, that after you close this transaction, when you no longer control the books, you want to be able to make sure the earnout uses as clear terms as possible. And any kind of another thing to do, if other than relying on past practices, is use actual examples. So go ahead and throw in the middle of your document. Let's assume revenue of X dollars and these costs, and this is how the calculation, and run through a calculation, just so you can show how the number is calculated. Okay. So I didn't mean to interrupt, but the second sort of dispute that I see with earnouts is really over the level of the buyer's commitment to the business after the closing. Oftentimes, the buyer will do things that will have a negative effect on revenue. For example, one of our clients was a professional who served patients, and she divided up her time into quarter-hour increments. And so that was how she ran her business. Well, after the closing, for some reason, the corporation that acquired the business changed her calendaring system so that she would have half-hour meetings. So she could only see 2 patients an hour as opposed to 4. Well, that definitely had an impact on revenue. Okay. And made it hard for her to achieve the earnout. Okay. So another thing that can get in the way of an earnout is just red tape, and that probably was as much in this scenario as much the problem as anything. Was she was a person that ran her own business for years and years and years, and then she was acquired by a larger corporation that had a whole overhead and a sort of bureaucracy that went with it, which made it harder for her to to earn the same amount of money that she was earning before, at least for her division.
Mm.
So those are issues that, to the best you can sort of anticipate them. And every deal is different, but you can usually anticipate things like that and try to address those in the contract.
And what I found is if somebody wants to do just a one-year earn-out, that can be tough because you may have some decisions of things you need to, decisions to make for the betterment of the company that if you make it, it's going to affect the revenues or the profitability, and then the earn-out isn't met, but it needs to be done for the, for the good of the company.
Right.
So if it's over a longer period of time, I think it will all work out. It can.
Right, and some other sort of interesting disputes that have come up over the years is one was a company was sold and had an earn-out, a 3-year earn-out, and then during that 3-year period it was sold again.
Ah.
And so you want to make sure that you've got protection for the earn-out if that should happen.
Wonder what would you recommend for something like that if it's sold? Would the earn-out be automatically due? Or
I think that the earn-out would continue even if the business is sold, and that there would be no issue. But the other you don't know that the other side may decide to make it an issue and take the position that the earn-out goes away because of the sale, and you may have. So it's better to have language in the contract that deals with the problem.
Yeah.
Under the strict reading of the law, the earn-out continues, just even if the business is sold. But it's definitely something you want to think about.
Okay. The next question is about promissory notes and securities. What is the biggest misconception involving promissory notes carried by the seller?
Right. Well, this is one I see very often, and it's usually the security for the promissory note is usually the assets of the business that's being sold. And the theory, it sounds really good in theory, that the seller takes a note for whatever it is, $100,000, 10, 20, 30, 40% of the purchase price, and if the buyer is unable to pay the note, then the seller moves in as a secured party under the Uniform Commercial Code and takes the assets back. Mm-hmm. And so it sounds really good because the seller would get the business back. They would also have whatever cash portion of the purchase price they'd have already received. So it seems like they'd be in a really good position. The practical reality, though, is that by the time the seller gets the assets back, they're not going to be worth as much as they were when the business was sold because, generally speaking, buyers, when they start defaulting on their promissory notes, they have bigger problems.
Mm-hmm. That's
and
true.
So the business has been harmed during this period of time that they've owned it. The assets aren't worth as much. The reputation of the business is not good because it's probably not paying a lot of its bills.
Mm-hmm.
It may have lost a lot of its key customers because it was unable to perform. Whatever reason that there's usually a reason the buyer's not paying the note. It's not just that the buyer doesn't want to pay it. There's also a period of time between the default and actually going out and enforcing the note and getting those assets. And that period of time the business will be more and more harmed. So it's nice if you can get other security, such as a personal guarantee from the buyer.
Mm-hmm.
And every deal is different, every transaction is different, but in some cases it might make sense to try to get a deed of trust on a buyer's home or something like that. But that's very rare.
Right, and if the SBA is
and the SBA would never allow it. If there's an SBA loan involved,
they usually second position. They're in first. So what are your chances of getting that? I like the personal guarantee myself.
Mm-hmm.
If it's worth a lot more than or if the note is worth a lot more than what the, let's say is left of the business if something happens. Fortunately, I've had very few of those. In fact, I'm trying to think of one that's they've had to take it back. I know it happens, but it happened to me many, many years ago, so I do know it happens.
Wow, yeah, no, it is very rare.
Yeah. Let's see. The next question is problems cause falling prices. So how important is that in preparation? How important is the preparation for the seller to keep that from happening?
Yeah, I touched on that at the outset, just in terms of how much I appreciate the way that Jones transactions are prepared. Usually, there's a binder, and it's got whatever skeletons the company has are in the binder already laid out there for the buyer to review. So the buyer knows, I mean, really it's like a courtship, the relationship between a buyer and a seller, and trust is very important. And a lot of things can be done, a business can do a lot of things incorrectly, and those things can reduce the purchase price. But there are other things that, if they're not disclosed, can actually kill the transaction. And so the types of things that hurt or lower the purchase price, the most common ones that I see out there are whether the seller did any securities law compliance when it issued shares to its founders or to any investors. A lot of times companies just don't think about, if they're selling stock or issuing stock to themselves, that's a securities law transaction and it needs to go through a process where there's filings made and that sort of thing. And if you forget to do that, buyers' attorneys, they love to hammer on that point and go, well, gee, there's all this risk created by this lack of compliance, and because of that risk, we want to push the purchase price down. Another common one in the Silicon Valley is companies will hire consultants to develop software for them, for example, and they will forget to get the consultant to sign over their rights to whatever inventions they create. And if you don't have a folder somewhere with all of those assignments from all your consultants, the buyer's attorneys are gonna just hammer that and say, well, you're making us take on a lot more risk than we realized, and they're going to push that purchase price down.
And having the books in good order is key also, isn't it?
Yeah, I mean, I've seen transactions where the seller feels really reluctant. They feel like, well, why should I show you these things? This is my personal, this is my company's financials. I don't want to show this stuff to you. I mean, if you want the business, buy it. If you don't, don't. They'll take that approach, and they don't realize, it sounds like tough talk, but they could actually lose the transaction. I've actually had people walk away from the table because they just got a bad feeling because the seller wasn't giving them access to the records that they needed to see.
Right.
And
then go ahead.
This particular example, the seller had actually a very good purchase price in front of him, got a little bit hot-tempered and reluctant to show the buyer any of his documents, and really reluctant to spend the time to even gather them. It lost the transaction, and a couple years later ended up having to shut down the business and not getting any money.
Oh, yeah. We try to educate our sellers to, let's don't even list it if you're not ready to put everything on the table, and disclose anything that's happened in the past, because nobody likes surprises, and then all the trust goes away, right?
That's the key thing, is you lose the trust. It's easy to disclose if you disclose something and the buyer doesn't want to doesn't want to go forward with the deal because of what you disclosed, that's a much easier problem to address. There's usually ways around, no matter what you disclose, there's usually ways to handle it.
Right.
But if you don't disclose something and then the buyer finds out about it, that creates an issue of, well, what else are you not telling me?
Yeah. And it can be innocent. That's why it's so important that in that seller's disclosure document that they go through that very carefully and make sure that they, that kind of jogs memories of maybe what could have happened with an employee 3 years ago that you're not thinking about now. Or is there a lawsuit and you've already put it behind you but you need to disclose it?
Yeah, and everything that you disclose is going to have an impact on the purchase price in a way, because the buyer is evaluating, based on your disclosures, how much risk there is. And based on how much risk there is, they're usually adjusting the purchase price. But undisclosed liabilities, it's a different issue. It's not really leverage on the purchase price. It's more about whether the deal is going to go forward or not.
And probably another thing that causes, that I've seen that could cause a price to fall is, let's say they're in due diligence, the purchase price has already been agreed to, now they're verifying everything, and they find out that one client made up a very big part of their revenue, and they found out that client just went away, and they found that out during due diligence. So definitely a price will be adjusted for something like that.
Mm-hmm. A common one too is on the other side. We had a client that made a food product, a cereal actually, and they were reliant on a particular supplier for this flavoring. And just as fate would have it, right before closing, the supplier sent a letter saying, we're going to stop producing this product. So they had to scramble and try to find an alternative supplier for that product, and they had to order mass quantities of the product before the company shut down the production. So,
have you ever seen a case where, because I've had sellers, ready to list their business, but they know that something big is coming up that is going to increase revenues. Have you seen it where the price is increased down the road? We don't have an offer yet, but we listed it for, let's say, $3 million, and then another big account comes. Do you see that happening very often, where prices can be changed during the deal?
I can't say that I see it happen very often, but it's definitely happened before.
It happened, yeah. Because brokers can get online at any time and make the changes to the different web pages of the price. So if there is something, a nice increase, we would want to change the price accordingly.
Right.
Okay.
Definitely.
Anything else on things that cause the price to fall that you can think of?
Well, every business is different, so it's really going to be driven by, like you were just pointing out, you have some businesses out there that have 80% of their revenue comes from 3 customers. That type of a business, one of those customers changes its policy or has a bad quarter, and it could be devastating.
That would be an example of an earn-out for sure.
And that's a great example of how an earn-out can really help solve a problem, because the seller doesn't want to sell for too low of a price, and the earn-out really provides security for both parties. Right.
Yes, and I think both parties would agree to something like that.
Mm-hmm.
So from your experience, what are the most common reasons some transactions fail to close? And then I can add a couple too, I'm sure.
Yeah, I'm sure you have several, but the most common ones that I see are time and commitment. Time is the number one killer of transactions, and that's if you're ready to buy a business or ready to sell your business, you need to be ready to act very, very quickly, and you need to make sure your team is ready to work quickly as well. This is where you want to make sure that you have an attorney who's done mergers and acquisitions before and is familiar and is willing to work very quickly. And also it's why it's so important to use a broker because they know that time is working against you the whole time you're trying to close your transaction. Any number of things can happen during the negotiation process, and it's a very tiring and draining process, especially for a seller who's used to running the business day to day. You can almost guarantee during the course of a transaction that your attention is going to be drawn away from your business. So instead of focusing on the business, you're going to be focusing on selling the business. There's a psychological feeling that's natural that once you start negotiating to sell your business, you're going to sort of slack a little bit in the way you attend to your business. So your revenues might drop a little bit, and the more time that goes by, the worse things get potentially for everyone. And one example, one of my first transactions years and years ago involved a semiconductor equipment company who, and that's a very cyclical business, and he was going through a really rough spell, and he wanted to sell to a larger company just to get out from under some of the debt. And it was really a fire sale. He wasn't standing to make any money at all on this transaction. For some reason, the buyer's attorneys took 6 weeks to turn around every draft of the document. So we did they drafted the document, we edited it in a couple of days and sent it back to them, and then we wouldn't hear from them for 6 weeks. So we went through 2 of those 6-week periods. So 3 months went by. And the client came in and said, I'm looking at my profit and loss statement and my cash flow, and I've gotten some orders in, and I can now see light at the end of the tunnel. And I don't think I want to sell this business anymore.
changed his mind. Yeah.
And it was great in this case. It was great for the seller because it was really not a good sale to begin with. But the buyer lost a tremendous investment amount of money because they were going to get this business for virtually nothing. And just because their attorneys didn't understand that look, we have an opportunity here to buy something for nothing. Let's just get the deal done quickly. Mm-hmm. Instead, they wanted to negotiate over every little point in the agreement, and then they wanted to just sit on the documents for weeks at a time. The deal went away.
Yeah. And I think what can happen, too, you've probably seen it, where seller and buyer are asking everybody and their uncle, their opinions while this is all going on. And so you're getting, 10 different pieces of advice, and people are saying, why are you selling it? I bet your son would like to take it over in 20 years. And, here he's already run it 25 years. He's a little weary. And, he'll hang on to it then. And then after he loses a good buyer, he'll realize, I don't want to give it to my son. So things can, I think getting all that different input can definitely put the fear in a buyer if time goes by, too much time goes by, and the seller can change their mind.
And that leads into the second thing, in my view, that kills deals is the commitment level. And if you're a seller and you want to make sure you're comfortable with the terms, of course, you need to be comfortable with the terms, but you also want to be committed to going forward with the transaction. Because there will be hiccups along the way. Every one of these transactions, I'm sure, Joan, you would agree that probably 9 out of 10 of your transactions have something that comes up along the way that nobody anticipated.
In fact, it's even on the broker exam, how many times does a deal fall apart before closing? And it's 3. So it's even on a broker exam.
That's interesting. 3, yeah, that sounds about right. I mean, there's always going to be a few things that happen along the way.
Yeah.
So it's good to understand that if you're committed to the transaction, it's important, and you'll be able to get through those things because there's a solution. To most problems, there is a solution.
Yes.
It just takes patience and a little bit of ingenuity to figure out the solution.
That's why I like working with you, because you can always figure out a solution to a problem. One of my most painful situations that I think the group will enjoy hearing is I had worked on a deal, had 3, this was before the recession, long before, probably 9-10 years ago, and it was, I won't say what kind of industry, but we had 3 really good offers for at least what he was asking. One was even more. And again, time, he kept dragging his feet, and so he decided on the buyer. We were negotiating terms, and at the last minute, he tells me, of course, I'm wiser now, too, than I was 10 years ago, but he tells me, I just talked to my accountant, and he said, I'm going to get hit too hard with taxes, so I'm going to hold on to the business. And, of course, I think I spoke with him. It took me a couple of years before I wanted to speak to him, but when I did, he said that, this was maybe 3 years ago I spoke with him, and his business is worth a fraction of what it was back then, where he could have, made millions for his business. So he, key to this, to anybody listening, and you're a potential seller down the road, is always talk to your accountant beforehand. Find out what your tax ramifications will be, and see whether it is the best time for you.
And taxes can be a good problem.
Yeah.
Because they generally mean that you're making some money. So
yes, but it definitely will affect it. If you get $3 million for your price of your business, and if it were all in cash, it's definitely not going to go all to you. Mm-hmm. But you never know. If your base, we won't get all into that, but your accountant can figure out creative ways to get the most of it to you, the biggest part of it to you. Okay, let's see. The subject of workers' compensation. And this is something that so many people don't even think that it would affect anything. But how is workers' comp affected when a new owner takes over, Raman?
Well, I'm not an expert on workers' compensation by any stretch, but basically my understanding is that companies are rated, and their insurance rates are based on their ratings. And so the more claims you have, the higher your rates are going to be. And, if there's an accident, any time before the closing, that can cause the rates to spike for the buyer. And if the rates spike for the buyer, that means that he's going to be, or he or she is going to be less profitable than she or he thought he would be, and they're going to be looking for a reduction on the price as a result of that.
Or possibly terms.
Right.
Okay.
And so that can be a real, and then also, it's a very complicated arena, so it's not something that you know exactly what the impact is going to be immediately. You need to get brokers involved and try to figure out, well, what is this going to, how much is this actually going to cost the buyer? And that, again, when you're working up against a very fast time frame to try to get the deal closed, it's hard to bring brokers in and get all that sorted out.
It can slow things down, definitely. And what about license transfers? I just did one recently that it can be very complicated. So are licenses automatically transferred to the new owner, or how are they handled, such as a contractor's license needed to run the business?
Right. Certain businesses require licenses to operate. So contractors, that's the prime example. In order to, if you go out and if you're a contractor and you go out and work on someone's house, if you're not a licensed contractor, you have no right to be paid. So you could go build a house for someone, and the person could say, well, that's nice, I'm glad you built me a house, but I'm not going to pay you because you're not licensed, and there's nothing you can do about it. So you need to make sure, obviously, that you're licensed. If you're buying a construction company, the buyer needs to be licensed. And really, depending on what type of a license we're dealing with, if it's a construction license or an alcohol license, it will have there'll be different ways of handling it. With respect to a contractor's license, you can solve the problem by doing a stock sale, in which in a stock sale, the license goes with the corporation, so there's no transfer happening.
Right.
But of course, most transactions are set up as asset sales and not stock sales for other reasons. And so what you'd have to do is go out and get the buyer licensed before you can close the transaction. And it could take 6 weeks. I mean, actually, they're working pretty fast right now at 6 weeks to 3 months to get a license processed. I think, Joan, you use an expert who can
expedite that.
Expedite the licensing process, and that's really an invaluable service. The other thing to think about is with the contractor's license, there also has to be a qualifying individual in the business. It's not enough to have the company license, but there has to be a qualifying individual. So that will usually be the seller agreeing to stick around after
the buyer
the closing.
Often does not have one. And it takes 2 to 3 years to get one, depending on his educational level.
Yes.
Okay. And that can be, from a broker's point of view, we have to educate potential sellers about that issue, because they might just think, I get to leave and be scot-free after I sell the business. And, we have to say, not so fast. If we sell to somebody that isn't licensed, then you may have to be the responsible managing officer or the responsible managing employee with there's different requirements for each one until they are qualified. So, the seller has to realize that.
Right.
Okay. So regarding employment agreements, is it a good idea to have an employment agreement? And I guess this is referring to sellers staying on, correct?
Right. And so an employment agreement, it really just depends on the business. But I mean, it's the basic rule is this: if you're a California employee and there's no agreement in place, you're an at-will employee and you can be terminated at any time, and you can quit at any time. An employment agreement usually is a little bit different than the typical employee relationship, in that it's got some guaranteed period of time where you almost have a guaranteed job. So the company will hire you for a 3-year period, and if it terminates you early, it will pay you some sort of a severance that's set forth in the agreement.
Okay.
So the nice thing about an employment agreement is if the transaction involves an earn-out or a promissory note, it gives you a really nice way to get probably the best security there is, which is you're still involved in the business.
Right.
And you can make sure that the customers keep paying their bills and that the suppliers keep supplying their products and that things work smoothly during the period of time that you have an earnout.
Mm-hmm.
The other thing I'll say is, still in Silicon Valley, the number one asset of most businesses out here are the people.
Mm-hmm. Yes.
And so when you buy a business, it is good to take the key employees and try to reassure them that just because the company's been sold doesn't mean that they're going to lose their jobs. In fact, here's an employment agreement where they can feel comfortable that they're going to have a job for a period of time.
Right. And I've noticed in the smaller transactions that I've done, a buyer is perfectly happy for the seller to stay on 3, 4, 6 weeks and just ensure a smooth transition with the employees, customers, but then they're ready for them to leave, because it's so tough to have 2 leaders to be trying to man the ship, so to speak.
Right. I mean, human nature sort of dictates that the seller has run things a certain way for a certain number of years, and they're comfortable with that. And they're going to have a hard time just by human nature with a new person coming in and running the business in a different way. Mm-hmm. And from the buyer's point of view, they're going to want to sort of have the opposite. It's only human nature that they'll want to make their mark. And probably the reason they wanted to buy the business is because they saw an opportunity to run it in a slightly different manner,
right, to
make it more profitable. And those two aspects of human nature are going to have some conflict with each other.
and the employees are going to automatically want to go to the old owner because that's who they're comfortable going to. Right. So yeah, that conflict for power can be tough. And I've seen there also, isn't there another name for it other than an employment agreement? Was it a service agreement or something that I?
Sure. I mean, you could also be a consultant, right? You can have a services agreement or a consulting agreement. You don't have to actually be an employee of the new company. Mm-hmm. You can just agree to provide services on an as-needed basis or for a limited number of hours. Mm-hmm. Oftentimes, the buyer just wants to know that you're there if they need you. They don't want you there every day, maybe. I even had one where they specifically built into the agreement that the seller would not speak with the employees after the closing during work hours. They would come and provide consulting advice and services, but they wouldn't go talking to the employees because the buyer was maybe a little too concerned about it, but realized that there's a natural interference that can happen in that situation.
Yeah.
So you don't have to. It doesn't have to be an employment agreement. It can just be an agreement to be available, maybe for a period of time that gets lesser and less over time.
Yes, and sometimes I've seen transactions where let's say 50, 60 hours is included in the purchase price, and anything over that of consulting they would agree on a hourly basis.
Very common. Yes, yeah. Definitely.
So let's look at the personalities of the parties and how that can play a part in this. And why is it important, Raman, for buyers and sellers to be on the same page?
Yeah, and this gets back to the point that really what's happening between a buyer and a seller is a sort of courtship, and kind of, especially if there's an employment agreement or an earnout or a promissory note, it's going to be a short-term marriage that follows the closing. And so the personalities need to be complementary to the extent they can be. Unfortunately, usually the seller is someone that's a sort of special personality that's an entrepreneur that started the business and built it to a certain point. And oftentimes the buyer may not necessarily fit into the entrepreneur category, but may be more of an analyst by nature. And they're looking at a balance sheet and they're saying there's a lot of opportunities to make money here that the seller is not seeing because the seller is an entrepreneur and not a numbers cruncher. That's sort of the classic, if for lack of a better word, stereotypical buyer and seller conflict. And then after the closing takes place, you have those sort of clashing personalities. It can be as silly as the new owner not wanting to spend money on office supplies because it just they may see things differently, or office lunches or whatever it might be.
Right. One is more big picture, and the other one's counting them.
And this is an area where, again, I mean, I don't want to harp on this too much, but a broker can really be helpful in finding the right buyer for you, because it's not just the person with the biggest checkbook.
Right.
It may be the person that can work with your employees the best to get the most out of them, and can work with your customers. Sure, a lot of people might be able to pay a lot for the business, but can they get in front of your customer and put on a good presentation?
Or are they going to even get to the closing table? That's
right.
one of the things I look at when I have 3 offers and 3 different personalities. I tell the buyer, look and see, first of all, who you think your employees are going to enjoy working with, who are you going to enjoy working with through the transaction, and then this is when I give my input, too, of I don't think this guy will ever get to the closing table. I've gotten to get to know them and, gotten into their head a little bit, and I don't think they'll ever get to the closing table. They're too much of a worrywart, or, they just are just too detail-oriented that they can't look at the big picture of where this business could go. So. And
I'm sure you feel that, there's no guarantees, but over the years you've developed radar for this, right?
You do.
You can see them coming a mile away when they're not.
Yeah. So if they don't complement each other, then it really can blow up, hopefully earlier versus later. But, especially if you're going to have an employment agreement and an earn-out, you need to know and have faith in this person that they're going to be able to run with it and make a success of your business. If you get all cash, you probably don't care quite as much, but you still care. And I've had so many instances where the seller truly does care more about their employees than they do about how much money they get, because it's their baby. They've worked for 20, 30 years with some of these employees, and they want them to be taken really well cared for. So great. Well, I think we've gotten to our question section. Thank you so much, Raman.
Oh, it's a pleasure.
Some good answers there. Let's see. Gaius. Oops, I'm not supposed to say names. One of the questions, Raman, was I've heard many people never paid the note. This doesn't seem secure for me. He's heard that a lot of people don't get paid.
Right. And there's truth to that. A lot of people don't get paid on the promissory note, and that's why you need to have someone looking at that note for you so the way we look, so we're attorneys, right? So we deal with the problems. More often than not, people come to see us. A lot of times they come to see us because they want to close a deal and do some and sell their business and make money and all that sort of thing. But really, we deal with a lot of problem transactions after the fact. So we try to protect you with some sort of security. The security might be a security interest in the assets. It might be a personal guarantee. It might be a deed of trust. It might be you can build in provisions that let you rescind or repurchase the business. It just depends on what we look at. We look at the buyer, and we determine what do we need to do to put you in a position where you're secure. Some buyers we're not going to really worry too much about because they have financial backing and other things. But other buyers we will worry more about. Right.
And we always make sure the seller runs a credit report and sees what their history's been like. And there's many people that you just wouldn't consider doing a note for. Right. Another question was, it says employees can quit anytime, but can seller? I guess.
Yeah, I see that question. That's something that even though you may have as an employee, you may have a 3-year employment agreement, but we don't have indentured servants in California, and so you can the employee can always quit, and the seller can always quit. Even though they've said that they'll stick around for 3 years, there's no way that you can hold them to that. However, when you sell a business, that's one of the few times under California law that you can be bound by a non-competition covenant.
Yes.
So if you sell your business and you sign a 3 or a 5 year non-compete and a 3 or a 5 year employment agreement, if you quit, you may not have a way of making a living.
Mm.
So in that sense, you're pretty much, you're not going to quit. You're locked in.
Right. But if the person is so difficult to work with and you don't have an earn-out, you may choose to do something else for the remainder of your non-compete and then can compete after that, right?
Yeah, there is nothing that stops any employee, seller or otherwise, from walking away from the agreement. The employment agreements are really, when it comes to the term of an employment agreement, it's only a one-way contract binding on the employer.
Okay. Okay. Well, I think that's it. We went a little bit over, but I think we all got a lot out of this, hopefully. And if there's any further questions, we have Raman's phone number there and email and mine. Feel free to call us with any particular issues that you might need counsel on or some help from us. And I appreciate it. And look for your next webinar invite. I believe we're going to skip March, but we will have another webinar that has to do with exit strategies in April. So thank you so much, Raman. It was greatly appreciated.
It was a pleasure. Thank you very much.
Okay, bye-bye.
Bye-bye now.
Thank you. Please stand by.